I'm hoping this, oh, it does work. Okay. Well, good afternoon, and I'm glad you all have an interest in this topic. And I want to kind of get a sense of, oh, I need that. Okay. I want to kind of get a sense of who we have in the audience, and I'm wondering how many of you have ever heard of Title VII? Okay, so there are probably some folks that maybe work in HR or maybe the law. That's a place you'd commonly hear about that. What about the California Fair Employment and Housing Act? Okay, and those are laws that generally prohibit discrimination, generally including gender-based discrimination in all terms and conditions of employment. And those are probably the more commonly known statutes that prohibit discrimination. What you may be less familiar with is the Equal Pay Act. How many people have actually heard of the Equal Pay Act? Not equal pay, but the Equal Pay Act. Okay, a lot of people, okay. The Equal Pay Act was enacted in 1963, so it just recently turned 52 years old, and it was enacted by JFK in response to concerns about outmoded and outdated concepts on pay and gender equality. And so in passing this legislation, Congress declared, quote, that it passed it out of concern for the weaker bargaining position of women and to combat an ancient but outmoded belief that men, because of their role in society, should be paid more than women. And that was back in 1963. So I guess the question is, do we still need something like the Equal Pay Act? What do you guys think? Yeah, it's kind of surprising that we might still actually need the Equal Pay Act. So what is the Equal Pay Act? The Equal Pay Act states, what you see on your screen, that an employer can't discriminate between the sexes in the payment of wages when the two groups are performing equal work that requires equal skill, effort, responsibility in similar working conditions. Now, the Equal Pay Act is more targeted than Title VII, which I mentioned prohibits discrimination in all terms and conditions of employment, because it focuses specifically on differences in pay between men and women in the workplace. There are some exceptions to the Equal Pay Act that we're going to go over, but what's interesting about it is that this claim is really one that's a lot easier to prove than Title VII claims, because it doesn't have an intent requirement. If you look at the language, it doesn't say anything about intentional conduct that's motivated by discriminatory animus, which is what we often hear about in Title VII cases. So here you don't have to prove that anybody had a bad motive. You just have to prove that it is. There is a difference between men and women in pay performing the same function. So the standards for proving the cases sometimes are more achievable, but ultimately these cases aren't as common, probably because the remedies under this statute are not as robust as they are under Title VII, where you can get punitive damages and emotional distress. Under the Equal Pay Act, you simply get the money that you should have been paid, and you can also get what's called liquidated damages, which is an amount equal to the amount that you should have been paid. But this law has a state corollary in California, and recently on August 31st, our state legislature passed a bill, SB 358, which threatens to make California's version of this law even more robust. And I wouldn't be surprised if the law passes, it's supposed to be signed into law by Jerry Brown in October, that you will begin to see many more Equal Pay Act claims. So that means as an employer, it's really important for you to understand what's going on in your workplace and make sure that you're in compliance. And as an employee, it's important to understand what your rights are. So let's talk about what the reality is that created the need for this In 1963, women earned 59 cents for every dollar that men earned. And it's good that we have limited the gap, but the gap definitely hasn't closed. And today, women are earning an average of 78 cents for every dollar that a man earns. Now, that gap grows when you start looking at women of color and people with disabilities. You're talking about a wider disparity. You're also looking at a wider disparity by industry. So you see wider disparities in information technology, computer science, banking, finance, engineering. An example, in engineering, women earned $48,000 when men earned $51,000. And this is about 1 year out of college with similar degrees, similar backgrounds, doing similar work. And this is a study that was conducted by the American Association of University Women in 2012. In the computer and information science arena, women were earning $39,000 while men were earning $51,000. It's a pretty substantial gap. In business, women were earning $38,000 while men were earning $45,000. So it does appear, based on this information, that there is something to address out there. Now, oops, how do I go back? Let's see. So I mentioned Title VII and the Fair Employment and Housing Act, and just emphasize again that the difference between those statutes and this has to do with the intentional component. And that's one of the main significant differences. And the reason I emphasize it again, especially for employers, is that it's important to remember it does not matter if you intend to treat men and women differently in the workplace. It is, you may in fact not intend. In fact, you may have terrific diversity and inclusion programming. You may have great sort of organizational mentality. Everybody may be very progressive and on the same page. But if, at the end of the day, regardless of your intent, regardless of all your programming, all the great things you're doing, you're sending people to conferences like this to become more aware, if you still have men and women performing the same job with the same responsibilities, etc., making different amounts of money, you may be running afoul of the Equal Pay Act. So I've mentioned some of the elements. First of all, when we look at who is being paid what, we're looking at the same establishment. So it's important to understand what we're comparing. Okay, we're looking at the same establishment. That law that I referred to earlier, the California law that's going to be enacted in October, we think, would actually broaden the same establishment requirement and could allow broader comparators, which means that you could compare employees in the same company in different establishments. Equal work. Obviously, equal work means that you are doing jobs that are substantially equal. They don't have to be identical. Job classifications and titles are not the controlling factor. Courts are looking at what do you actually do. That's going to be the key factor. Performance. You need to be performing with equal skill, effort, and responsibility. And skill takes into account the employee's experience, training, and ability. But if your credentials are not an element of the job, that would not justify a difference. Let's say you have two people performing the same work. One has a college degree and one doesn't. But having a college degree is not a requirement of the job and doesn't lend anything further. That's not going to be a basis for differential pay when the difference is between the genders. Another example would be effort. So the same effort required, but different kinds of effort. Let's say you're in a manufacturing environment and the people are working on a assembly line, but one person is doing screws and the other one's doing widgets. But the effort is the same, the work hours are the same, and the only difference are screws and widgets. That probably wouldn't be a basis for treating those two jobs differently based on gender. But let's say responsibility. Let's say they're doing the same job, but one person periodically acts as the lead or the supervisor. That could be a basis for a pay differential. So there are defenses: seniority, merit, quantity or quality of production. Seniority is a seniority system that is based on the length of your employment. Merit is a merit-based system based on performance. For example, if you achieve these milestones, you'll get a 3% raise. The woman achieves those milestones and the man doesn't. So the woman gets a raise, the man doesn't. Quantity or quality of production: if you process 10 widgets, you get paid more than if you process 5 widgets. And then factors other than sex. This is the big one that always gets people in trouble because it's abstract. What are factors other than sex? One example that people use is, well, I had to pay them more because they were making more, and I wasn't going to be able to hire them if I didn't pay them more. That actually is not going to be a defense to why in your workplace men and women performing identical or equal work are not paid equal. What you might have to look at is increasing the salary of those people who are not making enough if you want to be able to recruit people who are making more money, and recruiting them would create some sort of gender imbalance in the workplace. Now, it is true, though, that there are some examples of processes that might result in inequalities that are acceptable. For example, let's say that you want to retain somebody. Their job's being eliminated, you want to retain them, and you say, hey, if you stay, you'll keep your same pay, but we're going to move you into these other responsibilities. That's a factor other than gender. That's a factor other than sex that you're using to keep somebody who's already making a level of pay. There are many, many examples. I can talk to you afterwards if you're interested in exploring all the parameters, but there are some defenses that are available. What you should know about what to look for: this law is not administered by the EEOC like Title VII is, so you don't have to exhaust administrative remedies and you don't go through them to file a claim. But the EEOC has the ability to pursue class-wide systemic claims on its own. And it recently, in issuing its 2012 strategic initiatives, stated that it had 6 priority enforcement objectives related to equal pay: eliminating barriers in recruitment and hiring, protecting immigrant, migrant, and other vulnerable folks, addressing emerging and developing issues, preserving access to the legal system, preventing harassment through systemic enforcement and targeted outreach, and enforcing equal pay laws. These are objectives that you should be aware of just because they reflect an increasing focus on Equal Pay Act issues. And if you ever receive something from the EEOC that indicates that they're exploring wage disparities in your workplace, you should obviously immediately bring it to the attention of your legal counsel. And I'm going to wrap it up now, but I just want to tell you really quickly, it's important to be proactive. And what can you do? You can audit your pay systems. You may want to get a lawyer involved because that will give you the protection of attorney-client privilege as you look at yourself to see what you need to improve. You want to look at all of the documents that determine how pay decisions are made, that reflect pay decisions. And what you're looking for are any inequalities. And you maybe need to make some changes to your pay scale. It's also important to make sure you have the records necessary to do this audit. Finally, once you've done the audit, you've fixed the problems, what are you going to do going forward? Take a look at your decision-making process. How are you deciding how much people get paid? And do you need to eliminate some of the discretionary or subjective components of your pay practices? You also want to make sure that you, going forward, document very clearly all of the pay decisions. What are the initial salary demands? What experience or other factors are going into why you're paying this person the amount that you're paying them? And there are a couple of other items listed there, but it's really important to document your pay decisions so that you can explain them later and show that they're for factors other than gender. And it also makes sure that they are for factors other than gender, that you are processing it in an appropriate way yourself. Training is really important for your managers, and then revisiting your practices periodically, at least annually, to make sure that you haven't developed any practices that might cause you to run afoul of the Equal Pay Act. And I'm way out of time, so thank you very much. You feel free to ask me questions after if you want.